Okay, well, I say we go ahead and get started.
Okay.
Again, we only have a couple of hours for this presentation, and it is being recorded, so anybody that jumps on late can circle back around and pick up the beginning pieces. So this is a webinar about advancing permanency through adoption specific to the Indian Child Welfare Act. And I want to take just a second to introduce myself so you all know who's talking to you. My name is Delia Sharp, and I am currently the executive director of a nonprofit organization called California Tribal Families Coalition. And it's an organization that was put together by California tribes in order to allow for tribes to really have a voice in shaping the discussion about the Indian Child Welfare Act. It actually came out of an ICWA compliance task force. In fact, it's a successor organization to an ICWA compliance task force that was put together in 2015 at the invitation of then Attorney General Kamala Harris. And through the work of the task force, a 100+ page report was provided to now Attorney General Becerra that contains sort of ICWA compliance issues throughout the state of California and contains 20 targeted recommendations for how to start increasing compliance with the Indian Child Welfare Act from the tribal perspective. And of those recommendations, one of them is training. And so I'm very happy to be able to talk with you all today about ICWA and sort of specifically about the permanency options, although we are going to touch on all of the minimum federal standards that are applicable by this federal law. And with that, let's go ahead and launch in. Oh, you know what? I also just wanted to mention, in my previous role, actually 2 roles before this, I was the directing attorney of the California Indian Legal Services Office up in Eureka. And I did that for about 10 years, and a big part of my practice was representing Indian tribes in juvenile dependency cases where ICWA applied. So I've been a practitioner, also now doing more policy work and implementing new legislation and working with state agencies to increase compliance. So with that, let's go ahead and get started. Like, it's always fair for you to know who's talking to you so you get the perspective that it's coming from. But so the Indian Child Welfare Act, and hang on just a second, for some reason, Scott, this isn't letting me go through.
There you go.
There we go. Okay. Scared me for just a second here. I haven't done a webinar on Zoom before, so this is a little bit new and sharing screens, but it's going to be just fine. It's going to be great. So the Indian Child Welfare Act is a federal law that was passed by Congress in 1978 with the intention of protecting Indian children, Indian families, and Indian tribes. And it came out of a task force report that Congress had received that demonstrated that Indian children are being removed from their homes at rates far exceeding any other population. In fact, at the time, there were some tribes that had all of their children removed, literally like no children left within a reservation. And within kind of the larger ICWA presentation that we do spend some time really talking about the impacts of both state and federal policies as they pertain to Indian children and Indian tribes, because that context ended up being very important. So I do encourage you at some point, even though you're sitting through this webinar, which I absolutely commend, for you to either spend some time reading about the history of Indian tribes and families, or attend one of our in-person trainings. But so the Indian Child Welfare Act was passed by Congress in 1978 with the intention of creating minimum federal standards that apply to a series of cases, and we'll go through which cases ICWA applies to in just a second. But it provides those minimum federal standards to ensure that Indian children are not being removed from their homes sort of inappropriately, and allows for tribes to have kind of a say in what happens in those cases. And this quote that's on your screen right now comes from the California Judges Benchguide on the Indian Child Welfare Act that was put together by the Judicial Council of California. And it reads, While California tribes do not have primary jurisdiction over custody proceedings, it is important to bear in mind that an Indian child has an interest in his or her life as a tribal citizen that Congress has specifically sought to protect. Interests asserted by a tribe are not interests that compete with what is best for the child. Instead, they are calculated to protect what is best for an Indian child. And this has been an area that has been sort of heavily litigated, especially in the last decade or so, with all cases except for one really coming down, on the side of the Indian Child Welfare Act is really kind of plugging in that best interest standard. But there is absolute judicial discretion to look at what is in the best interest of any child throughout whatever proceeding you're in, of course. And the Indian Child Welfare Act does not take that discretion away. Instead, it just adds kind of another layer onto the practice that you're engaging in, right? So if you are in a dependency case and, the series of laws that apply are in the Welfare and Institutions Code, imagine a transparency slide, laying right on top of the Welfare and Institutions Code, and that's ICWA, right? And so you just have to kind of view that federal law is working within our state laws, okay? And we tried to make that a bit more seamless with the implementation of different pieces of legislation. The primary legislation in California having to do with the Indian Child Welfare Act was passed in 2006 by California Senator Denise Ducheney, who has since retired. It's SB 678, and it was intended to harmonize federal legislation in intent with California law. And as the slide says, in a way, it was one of the most far-reaching state laws in the country. And it's considered that because California has such a large population of Indians from non-California tribes, and because any Indian child who falls under the jurisdiction of dependency, delinquency, family, and probate courts are all within the scope. And so it potentially affects hundreds of tribes across the country. And I do want to just kind of back up there a little bit because there's a lot of information contained within this one bullet point, right? And I do want to point out that California does have the largest Native American population of any state in the country. And that's true both because we have a large number of tribes. We have 109 federally recognized tribes in the state, but also because we do have a very large, what's called urban Indian population. That as a result of federal government policies, a large number of Indian people from across the country were relocated to California's urban centers, primarily Los Angeles and San Francisco. And as a result, what we see today are what are termed large Indian ghettos. Excuse me. I'm trying very hard not to catch a cold. My daughter is homesick today, but it's all in my mind, that cough. It's not happening. In any case. So I point that out because I think that it's important to recognize that application of the Indian Child Welfare Act and compliance with the Indian Child Welfare Act in California, I think is actually more difficult, is more challenging than what we see in other states, which is, I think, part of the reason that we see state agencies and tribes really working together and grappling with issues around compliance. That in situations where you have a tribe local to a jurisdiction, it's so much easier to try to, reach out and work with that tribe, to really partner with that tribe in executing, the sort of overlay of this federal law onto the system that you are all hopefully very comfortable working within. Right? Then instead, if you have a situation where you have a child that's a member of the Cherokee Nation in Oklahoma, and you're in, let's say, Sacramento County, you're having to work over a great distance to try to figure out how to establish that partnership and ensure that that tribe has, an opportunity to fully participate as a party to the proceeding, which is a requirement of the Indian Child Welfare Act. And so throughout, I'm going to try to talk just a little bit about kind of how to ease some of those issues, recognizing, of course, that we don't have all day together, so not taking up all of our time with that. Also in California, so after SB 678 was passed, we have Assembly Bill 1325 being passed in 2009. And what that does is develops a new permanency option for Indian children in dependency cases called tribal customary adoption. And tribal customary adoption is really unique in that it does not require a termination of parental rights, but does still lead to sort of the permanency that you would envision with an adoption, right? And we'll talk a little bit more about that when we get to the adoption slide. But just know that this was a cutting edge legislation that California passed in 2009. It remains one of the only options for this kind of sort of creative permanency option for Indian children anywhere in the country. And unfortunately, it's kind of underutilized is what we found when we were doing the work of the task force report. And the reasons for that are kind of, they're delineated there, but just briefly, one of the big reasons is that there's a great misunderstanding about the application, both on the tribal side and on the county side. So I do want to spend a little bit of time there again, going over that later. But it is intended to increase permanency for Native American children, and is intended to do that within the social and cultural construct that applies to tribes, where tribes find that a termination of parental rights is inappropriate in just about all cases. But before we move on, just also want to point out here that it is only available in dependency cases. So it is not available in probate guardianship cases or private adoption cases or delinquency cases. Again, just dependency cases, and only applicable where a federally recognized tribe is involved. So not applicable if you're working with a tribe that is not recognized by the federal government. And if people have questions about that, go ahead and raise your hand or pop a question up in the chat box, and we can come back to that a little bit later in the presentation. Also, just before we move on from this slide, I want to mention that last year there was legislation passed, AB 3176. Again, that's AB 3176. And what that did is kind of update SB 678, that's that first bullet point there, and just essentially included some of the additional requirements that the federal government has imposed on states in the last several years. So that again, you know, if you just look at California law and you're not looking at the federal law itself or the federal regulations, that you would be in compliance with the requirements of the federal government. Really, again, trying to harmonize what the federal government is intending with the California sort of child welfare construct. So that, let's see if we can move to the next slide. There we go. Excellent. So we are going to touch on all of these things. We are not going to have time to go in depth, unfortunately, in any of them. So, you know, really going to kind of get a taste of what the federal minimum standards are, but not going to have a lot of time to kind of really dive into the practice, of each of them. But we're going to do the best we can. So within these minimum federal standards, though, I think that it's helpful to kind of break them up. So there are procedural standards and then substantive standards, right? So the procedural standards include the duty of inquiry, of asking whether a child is or may be an Indian child, and the duty of notice, right? That if a child is an Indian child, that there is a requirement to notice the tribe of the pending case, to notice the parents of the pending case. And so those are your procedural requirements. Those are considered kind of the gatekeepers, that if those aren't done correctly, that unfortunately you never get to the substantive standards of the law. And the substantive standards include active efforts, both to prevent the removal of the Indian child, and then if that's unsuccessful, to reunify. Also a requirement to have a qualified expert witness testify in an ICWA proceeding that really enables a judge to kind of view the case through the appropriate cultural lens to ensure that cultural misunderstandings are not at play in a removal of an Indian child. And then we'll also talk about ICWA's placement preferences that were really ahead of their time in 1978. And I think that what you will see when we go through them is that you know, as we have sort of progressed through time and we find ourselves here in February of 2019, that both state and federal law are really catching up with those placement preferences, especially, you know, as they require placement with relatives and in a child's community. We'll also talk about jurisdiction and right to counsel and some other sort of tangential items, and then review some of the judicial counsel forms. Sound good, everybody? I'm feeling that you're all super excited about that. Okay. So applicability. What cases does ICWA apply to? Well, in California, with the passage of that law we were talking about, SB 678, it made clear that ICWA in California applies to both voluntary and involuntary foster care placements. So that would include, you know, obviously all of your 300 level cases, but in addition, you know, if an Indian child is being placed within a voluntary placement agreement, that ICWA continues to apply to that placement. Also applies to all of our probate guardianship cases here in California. It does not apply, though, to sort of your typical family law divorce proceeding. If custody of an Indian child will be with a parent through the divorce proceeding, ICWA does not apply to that proceeding. It's not intended to sort of pit one parent against another parent, or even give preferential treatment to one parent over another parent. However, ICWA will apply to a family law proceeding under this family law code that you see here, 3041, and that's where placement of a child ends up being with a non-parent, right? So those situations where, you know, parents come into a divorce proceeding and they are you know, sort of so out of sorts that they're not able to adequately parent, and a child ends up with a guardian, whether, you know, a grandma or whoever else. In those situations, ICWA does apply to, you know, what started out as sort of a standard divorce proceeding. It also applies to declarations freeing a child from the custody and control of one or both parents, whatever that proceeding looks like. But specifically here, if a parent is voluntarily relinquishing a child through an adoption proceeding, ICWA absolutely applies. And then anytime there's a termination of parental rights, ICWA applies. And then voluntary or involuntary adoptive placements, including all proceedings under WIC sections 300, 601, and 602. And so the 600 sections are, of course, our delinquency provisions here in California. I will point out that there is a California Supreme Court case in re-WB that does limit the application, sort of the robust application of the Indian Child Welfare Act in delinquency cases. And you can take a look at that case if you'd like. What I'll tell you here, sort of within the time that we have, is that the duty of inquiry and notice continue to apply to those cases, that you still have to identify whether an Indian child is involved in one of those cases. And that's true, because then if you end up having to place that child sort of through the foster care system, ICWA will apply to that placement. And that's getting a little too in the weeds for what we can cover today. So I'm going to back right out of those weeds at this point, but just do know that if you're looking at a 600 case, a delinquency case, that ICWA's application is going to be a little bit more difficult to discern than a 300 level case. So at that point, you want to do some additional research or contact me. I'd be happy to talk to you. So we're going to look at the definition of an Indian child, because the application of the Act really pivots on the definition of whether a child is an Indian child. And this is the definition straight from the Indian Child Welfare Act. Just so you know, the Indian Child Welfare Act was passed in 1978, has never been amended. It's been the same statute that whole time, so no tinkering. We do have some different clarifications that have come out by the Bureau of Indian Affairs, but the statute itself has never been changed. And I share that because there's just some weirdness happening through the media these days that has been challenging that, and want to be really clear because that makes it much easier for you all. So, an Indian child. An Indian child is either an unmarried person under the age of 18 who is a member of an Indian tribe, right? So our option first is an unmarried person who is a member of an Indian tribe. So this would be a child that he or her himself has membership already established in a tribe. Or we have a child that is eligible for membership in an Indian tribe, right? So not a member yet, his or herself, but eligible for membership, and is a biological child of a member of an Indian tribe, right? So at that point, one of the parents has to have membership in an Indian tribe. It does not need to be the same tribe. So we have many, many cases where, let's say a child is eligible for enrollment in the Yurok tribe, but mom is enrolled in the Karuk tribe and dad is enrolled in the Hoopa Valley tribe. That's totally fine. That is just the nature of tribal membership. What I will also point out here is that this is when ICWA applies, right? So again, when you have identified a child within this definition, the Act fully applies to that case. Where things get a little more complicated is in a situation where you're still trying to determine if a child fits within this definition. And the guidance that I'll provide you is, it's now contained within California law, and it comes straight from the Bureau of Indian Affairs regulations that were promulgated in 2016 in December of that year. And what they say is that you assume that a child is an Indian child unless or until it's been determined that the child is not an Indian child. And with that, we're going to kind of move on, and we're going to come back to that when we get to inquiry, okay? So getting through some more definitions here. My bet is that, I don't know, at least 50% of you have not heard of an Indian custodian, which is totally fine. But it's a person, it's an Indian person who essentially steps into the shoes of a parent. So the definition here is an Indian custodian is any person who has legal custody of an Indian child under tribal law or custom or state law, or to whom temporary physical care, custody, and control has been transferred by the parent. So this can be done either in writing or orally. There is no sort of prescription for how an Indian custodianship is formed. But just to give you kind of an example so you can wrap your head around it a little bit, one of the times that we see Indian custodians used is if a parent is going to be unavailable for kind of a temporary length of time, right? So perhaps, a parent is going to enter a rehabilitation facility, right? A 30-day drug or alcohol abuse facility, for instance, or is going to be going to jail, or even just has to, attend a funeral on the other side of the country. We've seen that. And so in those instances, what they will do is they will leave their child, or may leave their child with another Indian person. The law does require, in order for a person to be an Indian custodian, that they are an Indian under the definition of ICWA, so a person who's actually a member of an Indian tribe. But they don't have to necessarily fill out any paperwork, which really throws kind of the way bureaucracy works, right? And because of that, we have actually created a form. California Indian Legal Services created and maintains on its website a form that is used by parents to kind of establish this guardianship. And it looks kind of like a caregiver affidavit, if you've seen those. But it can be terminated orally, right? So it's entirely voluntary in nature, and either parent can terminate that orally at any time. The interesting thing is that because an Indian custodian stands in the shoes of the parent, if there needs to be a removal from the Indian custodian, it's just as if that's a removal from the parent. That all of the both procedural and substantive laws around ICWA apply to that Indian custodian. And I promise you that this is actually the most confusing part of the entire act. So if that didn't sort of sink in, let it go. But just kind of know that there's a thing called an Indian custodian in the back of your mind. And so it will trigger at some point if you run into this situation. So intervention and validation. An Indian child, Indian custodian, and Indian child's tribe all have a right to intervene at any point in the proceeding. And that's an absolute right. So when we get to the judicial council forms on this, you'll see that, for instance, unlike most filings with the court that are sort of motions or requests to do something, an intervention by an Indian child, an Indian custodian, or a tribe is a notice to the court that intervention is happening. The state court actually doesn't have a right to not allow that to happen. And at that point, all three of those, so that the child, the Indian custodian, and the tribe all intervene as full parties to that proceeding. And at that point are entitled to all the rights and privileges of any other party to the proceeding. And I will just point out here that while there is a judicial council form that has been created to sort of standardize and streamline that process, it is not required. That an Indian tribe's representative absolutely may intervene in person without any sort of writing, that there's no preconditions set out in the federal statute. Okay, so invalidation. Invalidation is kind of a quirky way of creating an enforcement mechanism of the Indian Child Welfare Act without requiring kind of a full-blown appeal, right? And so if ICWA applies, the Indian child, the parents, the Indian custodian, or the child's tribe may petition any court of competent jurisdiction to invalidate the proceeding for not complying with ICWA. So if, for instance, inquiry was not done properly, meaning that the requirement of asking whether the child is or may be an Indian child wasn't done, and so because there was never determined that the child was an Indian child, the tribe was not noticed of the proceeding, or the parent was not provided with those substantive rights, then what the tribe can do or the parent can do is petition the court to invalidate everything that has happened in that court proceeding back to the date of that non-compliance with ICWA. And this can actually be done on appeal, but more so what happens, or for instance, what I did in my practice, if I had been in a case before a particular judge and things had gone kind of sideways because ICWA wasn't complied with, and the tribe called me, I might, as a part of intervention, also petition via the presiding judge of the juvenile court to invalidate that proceeding going back to the date of noncompliance. And it does a couple things. One, it enables a correction of the proceeding to occur without the delay that an appeal creates, because those appeal times create additional trauma for everybody involved, right? But it also kind of cleans things up, right? So that there's not this sort of non-compliance hanging over the proceeding, because the reality is that, and I'm sure that many of you have probably heard about cases being overturned because of notice, that a case can go through, it's like full, say, 2-year cycle. And, at the time that you get to the 2-6 hearing, a parent may appeal their case. And one of the things that appellate attorneys are trained to do as a part of that review is to look at ICWA issues is to specifically look and determine whether ICWA noticing was done properly. And so, well beyond the date of notice that should have been done, way back at, say, the detention proceeding, you move far along in this, and then all of a sudden, when you're looking at permanency, things are getting undone. So it's really important to both comply with ICWA, and then when tribes come in, we, at least as in my practice, and I would say all of the California Indian Legal Services attorneys, we really try to make sure that moving forward in those cases that they're clean, because that protects really the best interest of the child. Okay, moving along here. And I'm seeing that I need to speak a little bit louder. So absolutely, yes, thank you for sharing that. And I have a question here. If termination of parental rights does not occur, can the parents still appeal? They can, yeah, absolutely. And I'm going to actually circle back around and address that question when we get to the adoption slide, just so that we can keep moving here. But thank you very much for the question. And Scott, I'm trying really hard to move forward here, but it's not letting me. Awesome, thank you. Okay,
Hi.
Inquiry. So we talked a little bit about inquiry already, but here's what the actual standard is. In all child custody proceedings, the court and the petitioner, including a social worker, a probation officer, a licensed adoption agency or adoption service provider, or an investigator, must ask the child, the parents, the legal guardians, and the Indian custodian as soon as possible whether the child may be an Indian child, and must record the information, if applicable, on the petition. Now I feel like I'm yelling at you. So the intention of inquiry is to ask every single child, starting at the very first moment that there is any contact with a family or a child, whether that child may be an Indian child, and kind of throwing out this notion that you can identify an Indian child by the way that child may look. As it turns out, many children that are members of the Cherokee Nation have blonde hair and blue eyes. And so just really understanding that there has to be a series of questions that are asked. And the Judicial Council of California has done us a very big favor when creating the inquiry form on this that we'll get to a little bit later in the presentation, about actually presenting some questions that you might want to ask that get to inquiry. Because it's not actually as simple as just saying, is the child an Indian child? That one, because of state and federal government policies, many people that are members or eligible for membership in an Indian tribe will actually disclaim that heritage because it has historically resulted in children being removed, often for sort of no reason, right? And that's a historical situation that we find ourselves in today that we have to overcome. And so the recommendation that we give you is that as a part of your inquiry process, one, work through the establishment of a relationship, and two, instead of sort of asking the very direct question that may put somebody on the defensive, instead explain that, hey, so there's this federal law called the Indian Child Welfare Act that provides a heightened set of standards in cases, is this child or may this child be an Indian child? And one of the ways that you can identify that a child is or may be an Indian child is through things like where they live. Do they live on or near an Indian reservation? Or where they receive health care services? Are they receiving those services from an Indian health clinic or Indian health services? So kind of looking at the situation more broadly. Because through the process of inquiry, you get what's called a reason to know, or you don't get a reason to know or a reason to believe that the child is an Indian child. But if you do, then you have to move into what we call due diligence, which is taking sort of that, maybe that inkling that the child is or may be an Indian child and looking into it. Taking some next steps to follow up on the information that you have been provided. Scott, if you could help me out by fast forwarding the slide to the next one, please. So within that due diligence process, what you would do would be to ask relatives, for instance, if they have information about possible heritage with an Indian tribe. And if there's a tribe that's mentioned, actually reaching out to that particular tribe. So these are some of the circumstances that may provide that reason to know that a person having interest in the child actually provides that information. So, perhaps on the hotline level, when questions are being asked of the caller, there should now be always questions about possible Indian ancestry. So, if that person's providing information or any other person is providing information, that would provide reason to know. Again, if the residence or domicile of the child or the parents or the Indian custodian is within an Indian community, so that kind of on or near reservation. And then, again, if benefits are received through Indian Health. Scott, can we move forward, please? Awesome, thank you. So when there is reason to know that an Indian child is involved, unless it's determined that ICWA does not apply, you have to provide notice. So backing up here just a little bit, inquiry itself is the process of determining whether the child is or may be an Indian child, right? And then if you have any sort of reason to believe that the child is an Indian child, you do that due diligence piece to determine whether there's reason to know that a child is an Indian child. And if there's reason to know that a child is an Indian child based on sort of that additional groundwork that you have done, right? Talking to relatives, perhaps reaching out to the tribe, then you would move forward in providing notice to the tribe. And how do you do that? Well, there is a process prescribed in federal law, and we call it the green card notice, right? And here I'm actually going to share with you that we recommend two separate and distinct processes. One is an informal notice process, and then one is a formal notice process. And the informal notice process is as soon as it's determined that the child may be eligible for membership, right, so that ICWA would apply, making a phone call or sending an email, whatever that method of communication is within your particular county around ICWA, but reaching out to the tribe or tribes that the child may be eligible for membership in as soon as possible in order to start developing that partnership that will enable you to move forward. And we're going to talk about this again when we get to the active effort slide. But that's the informal notice, right? That's making sure that you are in contact with the tribe as soon as possible to start partnering on the development of that case, right? So you can actually do joint investigations. You can develop voluntary case plans together. The determination of whether to remove can actually be done jointly, that we're seeing more of that happen in California's counties. But the notice that we're going to talk about here is the formal green card notice. And this is sort of the most onerous requirement that you'll find in ICWA, and also the area of the act that is subject to appeal the most. There's a form, it's called the ICWA 030 form, that was created by the Judicial Council of California with the intention of sort of standardizing what notice looks like. And on that form, it will tell you exactly who needs to receive notice and what information should be contained on that form. You may not have all of the information, right? So you may not have all of the dates of birth or the dates of death for everybody that's contained on that form, which would include both parents, the child, both parents, grandparents, great-grandparents, etc. So the recommendation that we give is, 1, complete the form completely. There should be no blank lines on your ICWA 030 form. If you don't know the information for that particular line, write information unavailable or unknown. And it's really helpful for appellate purposes if you're backing that up with some context within your delivered service logs and then within your report. So kind of fleshing out what you did as a part of your due diligence to determine, whether the child may be an Indian child, which includes trying to figure out, all the information necessary about the parents, right? Those birth dates, those, dates of death. So again, just, making sure that you're filling out every single line completely. And they have to be right. You can't have misspellings of parents' names, typos for dates of birth, that all of those things will serve to make it so that when the tribe is reviewing it to determine whether that child may be eligible for enrollment or already is, that answer that you get back may be no. That for many tribes, the systems that they're using are not advanced enough to pick up on similar sounding names, and that within families, you may have lots of people kind of with the same name. So if your date of birth is off, it won't show, right? That there may be an assumption that, maybe it's a neighboring tribe or it just doesn't fit. So with that, having the information be accurate and having that form be filled out completely is absolutely crucial. And that's required in all of your foster care placement cases, so all your 300 cases, all of your guardianships, anytime there's a termination of parental rights. And you're going to send out your green card form at the detention hearing, okay? If there's questions about that, do utilize the chat feature. But active efforts. So the party seeking involuntary foster care placement, guardianship, or termination of parental rights must provide evidence to the court that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family, and that these efforts were unsuccessful. So, again, way back in 1978, ICWA was well ahead of its time, right? ICWA was the very first law sort of anywhere. Scott, if you could take us back to active efforts. I don't know what happened here. But the very first law that required active efforts, required services to be provided to a family to try to prevent the removal of the child from the family, which makes a tremendous amount of sense. And now, with Families First, we're actually seeing federal law catch up kind of across the board, but that hasn't fully been implemented in all states. But know that where there's an Indian child in the case and ICWA applies, services have to be provided to prevent the breakup of the family, and those have to be documented. And in order to make it through your series of initial hearings within the dependency case, detention, jurisdiction, disposition, you're going to have to prove by a reasonable doubt that those services were provided and that they were ineffective. So with that, what constitutes active efforts? Well, in California, it's assessed on a case-by-case basis. There is no cookie-cutter approach to this. And those services must consider the prevailing social and cultural values and way of life of the Indian child's tribe. Active efforts to provide services must include pursuit of any steps necessary to secure tribal membership for a child if the child is eligible for membership in a given tribe, as well as attempts to use the available resources of extended family members, the tribe, Indian social services agencies, and individual Indian caregivers. So, one, you have to reach out to the tribe to determine, what the prevailing social and cultural values are there. But just to try to make this a little bit more tangible and concrete for you, one of the things that often comes up is that instead of an individual utilizing AA because of its roots in sort of Western Christianity, that there would be a culturally appropriate substance abuse service that might be available, something along the lines of Red Road, that's much more based within Indian community standards and really incorporates culture and responsibility as a tribal member to the community within how that service is provided. And just a contact to the local tribal community can provide the information that you need there. And then that second bullet, where you have a child that does not yet meet the definition of an Indian child, but it's clear that, but for some sort of paperwork and administrative process, that child would be, able to be a member of a tribe and therefore have the act applied. You should work with the child's tribe to figure out the information that they need and then get that provided. And I do see this question over here. Let me just pause for just a second. It's kind of a long one. What are your thoughts on when an Indian child custody proceeding, e.g. disposition hearing, is continued to a different date? Do you think that full ICWA 030 and certified mail return receipt requested is necessary? Or do you think that, e.g. first class mail is sufficient for continued hearing dates if the notice for the first hearing complies with the full noticing? I would love to tell you what I think about that, but what I'm hearing is that individual counties right now are handling that differently. And I would encourage you to reach out to your county council and get a legal opinion specific to that, because again, most counties are kind of developing their own practice around that. And if your legal counsel wants to reach out to me, happy to have that discussion, but don't ever want it to appear that I'm providing any sort of legal advice that may be in contrast to what your county counsel would share. So sorry for being a bit squishy there, but we get to talk now about qualified expert witnesses. So we chatted for just a moment at the beginning about why there's a qualified expert witness testimony within these cases, right? And that's to kind of ensure that the judge and really everybody working within the case is looking at the case through the appropriate cultural lens, right? Really understanding that, this particular case is different than the last case and different than the next case that you're going to deal with, because this particular child is an Indian child and a member of his or her tribal community, and wanting to ensure that decisions are not being made or judgments cast within this case based on sort of a misunderstanding or cultural bias, if that makes sense. So before the court orders foster care or adoptive placement, establishes a guardianship or terminates parental rights, the court must require testimony of a qualified expert witness regarding whether continued custody of the child by the parent or Indian custodian is likely to cause the child serious emotional or physical damage. That qualified expert witness should be a person knowledgeable with the culture of that particular tribe. In California law, that person can not be an employee of the agency seeking the foster care, placement, or termination of parental rights. Cannot be basically the social worker or anybody within that agency. And you'll see the list there of the persons most likely to meet the requirements for a qualified expert witness. I'm not going to specifically go through them. What I will say is that it's very important to reach out to the child's tribe to determine if they have sort of a social or cultural expert or elder, that those individuals often serve as the tribe's qualified expert witness. The Judicial Council of California, at the link that you see here on the slide, does maintain a list of individuals that do testify as qualified expert witnesses or have, but it does not necessarily mean that they would be a good fit for your particular case. It's very important to reach out to the child's tribe, because it should be a person who's familiar with that particular child's tribe and that particular child's Indian community standard. Okay. So with that, we're going to move on to placement preferences. And as I mentioned at the beginning, these were, way ahead of their time in 1978. But I think as we sort of march through them, that what you'll see is that they really fit with kind of practice, that you would apply to any case. So there are two different sets of placement preferences. The first applies to the reunification period of a child welfare case, so foster care, also to guardianships and custody to a non-parent, right, that kind of quirky family law context. And then the second set applies to adoptive placements. And the reason that there are two is just the difference between the sort of federal child welfare system, where there are very distinct proceedings, right? There's a proceeding for foster care and then a very separate proceeding for permanency. But in California, we have more of a continuum, right? Where we just kind of march through our various hearings: detention, jurisdiction, disposition, a bunch of review hearings, permanency. And so they don't fit super cleanly, but it's important to understand that, because when the adoptive placements apply, it tends to really throw things, right? When a tribe comes in at a 2-6 hearing, talking about wanting a change of placement, that feels very abrupt within our California system, but it's not within the federal system. And keep in mind that ICWA is a federal law. So with that, if the child is an Indian child, the court must order the least restrictive setting that most approximates a family situation within reasonable proximity to the Indian child's home and meets the child's special needs, if any. And then there's an order of placement. But do keep in mind that first part before you just look at the preference order. Keep in mind that there's supposed to be a holistic view that shapes how you're going to apply this preference order, okay? And the preference order really is pretty similar to what you would be looking at for placement of any child, right? That you're going to try to, of course, always place children in the least restrictive setting that most approximates a family situation, especially given new California law with the continuum of care reform. And, with things like school of origin, always trying to keep the child kind of within that child's community, and always looking at a child's individual special needs. Okay, so with that, the preference order is 1, try to place the child with a relative, essentially, a member of the Indian child's extended family. Do know that the definition of extended family is different than relative within the Welfare and Institutions Code. So you actually want to go and pull that definition. It's not quite as broad as in California's. Also know that the beginning of that definition requires you to defer first to the tribe's definition of extended family before you get into the rest of the definition. Meaning that if a tribe says that X person is within a child's extended family, say a second cousin, then that would be your definition of child's extended family for purposes of that particular case, instead of the sort of list that is contained within the rest of that definition. Okay. So the second here is a foster home licensed, approved, or specified by the Indian child's tribe. You will note here that this is not necessarily a home where an Indian person or 2 Indian people, live, right? So this is instead a foster home that's either that the tribe has licensed itself or the tribe has approved or specified, right? So we do have situations, say, let's use the Cherokee Nation example again. So you have a child that's a member of the Cherokee Nation, cases here in Sacramento County, right? So the Cherokee Nation, is unlikely to want to transfer that case back to Oklahoma, even if they have placement with grandma on the reservation during reunification services, right? Because that would eliminate the ability of a parent to be able to visit with that child and maintain that all-important parent-child bond during reunification services, right? So instead, Cherokee Nation may very well work with Sacramento County to identify a non-Indian foster home here in the county that would be then approved or specified by Cherokee Nation, and therefore still falling within the placement preferences. But importantly, providing that level of deference to the tribe about where that child should be placed. And within those conversations, as a part of that overall partnership between the county and the tribe, it's really, really important for the tribe to engage in a discussion with the prospective foster parents about what it looks like for a child of that particular tribe to be in their home, right? So for instance, are there ceremonies, are there cultural ceremonies that that tribe would expect that child to attend? And are those foster parents okay with that? Or are there dietary restrictions or restrictions on cutting of the hair? Whatever it looks like. And it varies between tribes, but you ideally want to have that conversation before placement of the child. If there's no extended family available and it has been impossible to identify a foster home that the tribe would approve, then you look at an Indian foster home that's licensed or approved sort of by the state essentially, right? Or by anybody else within California through the RFA process these days. And then if that is not available, then you would look at an institution approved by an Indian tribe or operated by an Indian organization that has a program suitable to meet the Indian child's needs. So most often that's a group home that the tribe has, approved, understood that it's important for, that placement, usually on a temporary basis. If it's impossible to place within this placement preference, then you have to get a good cause finding from a court to deviate. That while social workers have a tremendous amount of discretion over placement in all other cases, when it comes to cases where the Indian Child Welfare Act applies, placement must be pursuant to this preference order, inclusive of that holistic standard at the beginning. And if that cannot happen, then that case has to be back before the Superior Court judge for a good cause finding to be made. And the burden is on the county to demonstrate that a good cause finding is needed, that either there's a reason that you have to deviate from the placement order, or you just don't have a home that fits, right? That happens. And then the adoptive placement order is a little bit different. So you're still looking at extended family, but then instead of looking at sort of a potentially non-Indian home that the tribe approves of, you're looking at a member of the Indian child's tribe. And if that's not available, then another Indian family. So really, coming back to that congressional intent of having Indian children maintain their contact with the tribe and ultimately be placed within the tribe. Tribes by resolution may alter the preference order. And if tribes do that, then that becomes the preference order for that particular case. It worked, yay. Okay. The preferences of the Indian child and the parent must be considered within placement through that set of preferences that we just went through. Placement standards must be the prevailing social and cultural standards of the child's tribe or the Indian community in which the parent or extended family member resides or extended family member maintains social and cultural ties. So what that means, for instance, if the tribe is not approving it, but instead a home is going through the RFA approval process, that approval process still needs to look at the prevailing social and cultural standards of the child's tribe or the child's Indian community. So where this is operated in the past is that, there are not enough beds in a particular home, right? Or you're putting more children in a placement that would be allowable by the California licensing standards. If that's acceptable through the child's social and cultural standards, then that placement would not be prohibited. And so that requires working with the tribe to determine what the tribe's sort of licensing standards are. And a determination of the applicable prevailing social and cultural standards may be confirmed by the Indian child's tribe or qualified expert witness testimony, which is one of the reasons, again, why that witness really needs to be connected to the tribe, that it doesn't work well if you have, an Indian person from a sort of out-of-state tribe that is testifying about the ICWA placement preferences, unless that person has really worked with the child's tribe to understand what those social and cultural standards are for that particular tribe. Last thing here is that CDSS must maintain a record of each placement of an Indian child and the active efforts that were made to comply with the placement preferences. And that's largely done through its 58 counties. And the new case management system should make that much easier to pull that information when necessary. So we chatted for just a second. I just threw this information in on the qualified expert witness slide earlier, but that burden of proof to place an Indian child in foster care or appoint a guardian and award custody to a non-parent is clear and convincing evidence, including testimony of a qualified expert witness. And the burden of proof to terminate parental rights is beyond a reasonable doubt, which is the highest burden that you can really have. So if you're going to terminate the parental rights in a case involving an Indian child, just know that that burden is very, very high. And in order to meet that burden as an initial threshold, you have to have testimony of a qualified expert witness. So in ICWA cases, you're going to have your testimony of your qualified expert witness at 2 separate times in the proceeding. One in California at your dispositional hearing, and again at your permanency hearing, your 366.26 hearing. Want to throw in here that one of the things that became required under California law as of January 1st of this year is that failure to have a qualified expert witness ready and willing to testify does not in and of itself operate to extend timeframes, right? To get continuances of, in particular, disposition. And the reason for that is that we were seeing disposition continued over and over and over again for a county's failure to have a qualified expert witness. And what that was doing is it was eating into a parent's reunification timeframe, right? Because that timeframe starts to run from the date the child is removed, right? Your initial 6-month date, starts counting at disposition. But once you get to 12 and 18 months, the date moves back to the date of removal. And so it was really, making it difficult for parents with, really entrenched substance abuse issues, for instance, that are rooted in things like historical trauma that just take time to work through to be able to adequately reunify with their children. Also, in cases involving Indian children now, disposition is supposed to happen at the 30-day mark. It is no longer 60 days. It is now 30 days. So just encourage you all to be reaching out to supervisors and county council about what that looks like. But we do not have time to get into all of that today beyond what I've just shared. So now you know. So we talked just for a second about there being good cause to deviate from the placement preferences. Again, the party requesting the different order has the burden of establishing good cause. So if you're a county social worker and you want to place outside of that prescribed order of placement, again, you have to go to the court and demonstrate that there is a good reason to do that. And you'll see the 1, 2, 3, and 4 on the slide here include some considerations that the state court may consider. Okay, adoption. So first thing here is that a court must provide to the Secretary of the Interior, which is a federal branch, a copy of the adoption order or other information needed to show the items listed there with regard to the Indian child. Right, that a tribe or an Indian parent should always be able to go to the Secretary of the Interior within the Bureau of Indian Affairs and know where the child was placed. That there shouldn't be any secrets about this. And for a long time there were, which is why this requirement exists in the first place. I'm also, while we're on this particular slide, going to take just a minute to talk about tribal customary adoption because it's, again, it's that permanency option that's available available in cases involving an Indian child where a tribe is comfortable with it, okay? So as we said earlier, tribal customary adoption is only available in dependency cases, right? It is only available where there's a federally recognized tribe that has intervened in that proceeding, okay? Beyond that, what you need to know about tribal customary adoption is that it is not an option at all unless the child's tribe wants to go that route, because it requires the Indian child's tribe to actually develop the tribal customary adoption order, right? Where typically the state court develops the adoption order. Where it's a tribal customary adoption, the state court proceeding is actually sort of put on pause at the 2-6 hearing. And then the tribal court picks that case up to develop the tribal customary adoption order. The tribe at that time also conducts a home study, and the tribe can designate another entity to conduct that home study. So often what we see is that a tribe will designate a county to conduct the home study, and then the county will contract that out to a private adoption agency, okay? But then it becomes the responsibility of the tribe to approve that home study. So whoever does the home study will ultimately develop a report for the home study, right? That report is then provided to the tribe for the tribe to review, and the tribe will approve or disapprove it and then document that for the superior court. The tribal customary adoption order itself and the approval, let's say in this particular case, we're not disapproving, right? We're approving the home study. Both then get filed back with the superior court. And then the case kind of moves forward from there as a typical adoption would. But this is important to understand. The case does not just end there. You don't dismiss jurisdiction of the case once there's a tribal customary adoption order in place. But what happens at that point is it picks up kind of at the same place that a typical case would pick up once there's an adoption order in place, right? So there still has to be, all of the forms submitted to finalize that adoption through the state court proceeding, including the negotiation of the adoption assistance of payment. And I just share that because for whatever reason, in the last year, many counties started to just dismiss dependency at that point in the same way that you would if a probate guardianship had been put in place or something along those lines. So just know that that's the case, that there's more to do. With that, we're going to continue marching on. There's a lot to cover in 2 hours with regard to ICWA. So jurisdiction and transfer. So California is kind of a quirky state. California is not an exclusive jurisdiction state, but there are many states that are. So if you have a child from a state that has, if a child from a tribe, when the tribe is located in a state where the tribe still has exclusive jurisdiction, then that child must be returned to that tribe, that the state of California has zero jurisdiction over that child in that case. There can be an emergency removal of a child that is a member of a tribe that has exclusive jurisdiction over child welfare cases. There can be an emergency removal. They're always, always, always going to protect children. But if, when that child is identified as an Indian child, there's contact made with the child's tribe, and the child's tribe says, we have exclusive jurisdiction over child welfare cases, then you're going to immediately contact county council and figure out how to transfer both care and custody of that child to the child's tribe, doing so in a manner that ensures the child's safety. Okay. Again, we don't have any tribes in California that have exclusive jurisdiction, actually, with the exception of the Washoe tribe that is just on the border between California and Nevada. But you will know that they have exclusive jurisdiction because they will tell you. Also on the slide, we have transfer to tribal jurisdiction. A parent, an Indian child, or the tribe can petition to transfer a state court child welfare case where the ICWA applies to the tribal court. And the state court must transfer that case to the tribal court unless there's good cause not to transfer that case. And that's very much a case-by-case determination. But what I will tell you is that good cause cannot be the distance between where the child is located and the tribe, right? So if that case is here in Sacramento County and we're transferring it to an Alaskan village, just that distance is not reason to deny transfer, because a tribe can mitigate that distance by utilizing telephonic appearances in their court and fax filing, things of that nature. It can also not be, the good cause cannot be based on a determination made by a state court that the tribal court venue is essentially not something that a state court is used to, right? That many tribal courts look way different than a state court proceeding with judges that are not in a black robe and sitting up above everybody else. And that in some cases they're elders panels or peacemaking panels. So that will not operate as good cause. Okay, right to counsel. You all know this. A parent, an Indian custodian, an Indian guardian, if indigent, all have a right to court-appointed counsel. And of course, here in California, minors have that right as well. As full parties to the case, entitled to the rights of any other party, rights the same as any other party, tribes and the parent and the Indian child, etc., can examine all court documents related to a dependency case. And just last week, actually, CDSS issued an ACL 18140 that's entitled Tribal Access to Records, that has clarified that tribes are entitled not only to examine all court documents related to a child's dependency case, but really entitled to the entire sort of case file, to review the entire case file, which would include sort of county records. That's important information in order for tribes to be able to partner with you all through the pendency of these cases. So again, that is ACL 18-140. So full faith and credit. We're going to go over this super duper quickly. So let's say the tribe in a tribal customary adoption case has developed a tribal customary adoption order, right? So that's the order dictating what will happen with a particular child with regard to ongoing visitation. It'll specify that child support obligations cease and sort of anything else that an adoption order might contain, within that particular tribe. So when that adoption order is filed with the state court, what the state court does in order to make it fit within the state's child welfare scheme is to give it something called full faith and credit. And imagine it like a giant rubber stamp, right? That the state court judge is going to take this tribal order and it's going to take his big rubber stamp and it's going to stamp it. And when it stamps it, it makes it a state court order. And that's full faith and credit. And with regard to ICWA, state courts are required to give full faith and credit to the public acts, records, and judicial proceedings of any Indian tribe. So anytime a tribe is filing something like an adoption order or a tribal council resolution, then the state court looks at that, and as long as there's not a problem with a violation of California's public policy or a due process issue, and due process is just notice and an opportunity to be heard, then that state court has to give that tribal court document full faith and credit. Again, that giant stamp. Okay, right to additional time. This slide should really be way back with notice. But with the exception of the detention hearing and jurisdiction hearing, in cases where ICWA applies, the court cannot proceed until 10 days after the receipt of that green card formal notice by tribes. Okay, so this most often is applicable at our dispositional hearings. So those would get initially kicked out at least 10 days after receipt of notice by the tribe. Ideally, those notices went out the moment that child was removed, and so that time frame has already expired, because we don't want these continuances, right? They're not good for kids or families. If the tribe does need additional time to prepare, there's a statutory 20 extra days, right? So if a tribe gets the notice and needs an opportunity to be able to look at the record and go through the internal process of determining what the tribe's position is on this particular case, the state court has to grant that tribe 20 additional days to prepare in order to come in and exercise its rights as a party. Excuse me. So this is a list of the ICWA forms that have been put out by the Judicial Council of California. We are not going to go through all of them. They're actually in the process of being updated, but even as is, they are very, very helpful and mandatory. So you do want to take a look at them. There's an information sheet with regard to inquiry that provides that list of what I called helpful questions earlier. Encourage you to take a look at that if you haven't already. The ICWA 010 is a mandatory form that should be fully completed and attached to every single petition that's filed, whether or not there is any reason to believe that the child is an Indian child. Again, that's a mandatory form that should be filed with every single child welfare petition in the state of California. The ICWA 020 is our mandatory form for notice. Again, that's California's attempt to really standardize that process so that we cut down on mistakes and appeals. The ICWA 030, again on notice. The ICWA 040 is that optional form that tribes can use to intervene in cases. Again, you'll see that it's a notice. It's not a request or a motion. It's just a, here we are. But what it does, what is helpful about it, and I encourage tribes to use it, and if a tribe contacts you, I would encourage you to make sure that the tribe knows that it's available, is it provides a written form for the tribe to designate where they want future notices to go, and allows for a tribe to, for instance, have a notice go to both their social worker and their legal counsel. So just really cuts down on time for review there. There are forms for requesting transfer of the case to tribal jurisdiction. So those are all available on the California Judicial Council website. There's some helpful links here. Both the Judicial Council of California Tribal Projects Unit, as well as the California Department of Social Services Office of Tribal Affairs, maintain very helpful websites. I encourage you to take a look at them. There are a lot of resources that have been developed in partnership between state agencies and tribes. And if there's something there that you think would be particularly helpful, I would encourage you to reach out to, in particular, the CDSS Office of Tribal Affairs, because our goal is to increase compliance through providing enough information that ICWA compliance is sort of easy. And with that, do folks have any additional questions? And Scott, at this point, I would ask if you could please unmute so that we can just engage in dialogue versus sort of the chat function. Okay, so I'm going to come back to this question. If a termination of parental rights does not occur, can the parents still appeal? Yes, the parents can appeal any order of the juvenile court. So absolutely, the parents can still appeal. And that question related to tribal customary adoption, right? So yes, and we have seen, we have 3 appellate decisions specific to tribal customary adoption. INRI HR out of Del Norte County is the appellate case most often cited with regard to tribal customary adoption. And what it said is that tribal customary adoption is basically the best option for Indian children, that it should be the default option for Indian children, because you don't want kids as much as possible to be in long-term foster care. Guardianship, can work. We see it in a lot of cases as the permanency option, but the reality is that the funding source is not intended to be sort of permanent in nature in the same way adoption assistance payments are, and allow for negotiation. And it doesn't, when you're looking at permanency, it's important, I think, to not just look at what's working for the child and the guardian, because when you're looking at a guardianship, the child support obligation for the parents continues, meaning that they're never going to get out of that hole that they're in. And, at least from a tribal perspective, the intention, the hope is that, through the process of providing services and being involved in a family, that a point of wellness can be reached, right? Does anybody have any questions or comments? I feel like I shared a lot of information with you. No questions?
No, that's not till March 9th. Oh, that's March 9th, but that's not our next court date.
Okay, so Scott, do you want to spend some time going through tribal customary adoption then?
Someone had a question, but I couldn't tell who it was that was talking. Possibly whoever it was that had that question. It seemed kind of long. Maybe put it in the chat like, oh, who it was that was talking.
July 2nd.
I feel like it's possible that when we unmuted people, they weren't prepared for it.
I guess so. Everybody is unmuted. Oh, okay.
After TCA orders have been given full faith and credit, can we schedule the adoptive placement signing? Yes, assuming that the adoptive parents have filed the appropriate paperwork, you absolutely move forward with the process. Thank you for that question. Any other questions?
They can also type it in the chat.
Can you speak about the interface of resource family approval and tribal customary adoptions? Yes, I can. It's confusing as all get out, and we've been working closely with CDSS to try to fix it. As it turns out, I think that when resource family approval was put together, it was done without a hard look at how it was going to impact ICWA and tribal customary adoption, right? So with RFA, the approvals are done at the beginning of the case, and the intention is that an adoption home study, or at least a full-blown adoption home study, is not required then, sort of at the back end, at the permanency end of a case. But tribal customary adoption is a home study up to the tribe, right? And so the question has become, if you have a family that went through the RFA process initially, and now TCA is the permanency option that's being looked at, is a full-blown home study required? And the answer is, it depends on the tribe. It depends on what the tribe is requiring. Often, so far in our experience, that answer is yes, a full-blown adoption, a tribal customary adoption home study is required. And the reason for that is that as of now, the RFA process is not adequately integrating the Indian community standards. There's really no place within RFA for there to be a determination of what the Indian community standards are or should look like. And so, going through the full adoption home study process allows a tribe to, go through that process of making sure that, the prospective adoptive parents, really understand kind of what adopting this child is going to look like, and that they're an appropriate home for that child. And what did I mean by, oh, appropriate paperwork? It's the petition for adoption, sorry. Some counties aren't actually using the sort of standard judicial council petition for adoption. So the question here was, so after the TCA orders have been given full faith and credit by the state court, you know, can the scheduling of the adoptive placement signing happen? And it can, assuming that the parents have already filed that petition for adoption, that really you can't sort of leapfrog over any of the requirements that exist in the process, right? So again, kind of looking at tribal customary adoption as that transparency overlay onto, you know, now the adoption process instead of ICWA onto kind of the Welfare and Institutions Code, not taking anything away, but for the state court developing the adoption order, right? The tribal court is developing the adoption order, and the tribe gets the final approval of the home study. But everything else in that process still happens exactly the way it should have before. Does that answer the question? And you're unmuted if you just wanted to share or ask a question directly. I like talking to people. I wish I could see you all. Of course, then you probably want to see me. And I'm at home. The other thing about tribal customary adoption that I'll share is that you can have both the biological parents and the adoptive parents' names on the birth certificate. And that's something that would be laid out within the tribal customary adoption order that's developed by the tribe, is, you know, what the birth certificate should look like. But where it comes back to you is that you basically have to take that tribal customary adoption order that, once it's given full faith and credit, is your state court adoption order, and assist the adoptive parents with filing the required forms with vital statistics to get the amended birth certificate, right? And initially we had some real problems with vital statistics where they went, yeah, that doesn't work within our form. But good news, I think that those have all largely been resolved now, because we've seen several birth certificates come through that are able to list both sets of names. And what that does is it allows that Indian child to inherit through both the biological family and the adoptive family, which is super important for Indian children, because the federal government continues to be in charge of probating the estates of Indian people. And unless you have both sets of, unless you are able to show that there was no termination of the biological parents' rights, that Indian child otherwise would not be able to inherit tribal land or individual Indian money accounts, or participate in, you know, ongoing settlements between, you know, various tribes and the federal government for, you know, massive mismanagement of tribal resources, that kind of thing. But it's largely the land piece that, again, if there's a termination of parental rights, sometimes it actually operates to terminate a child eligibility in a particular tribe, but also it will sever the ability of that child to inherit through the biological family, severing that child's connection with tribal land, which would include, by extension, hunting and fishing rights, for instance, or the ability to, you know, be buried in a family cemetery. So there's a lot of rights that flow from that, which is why tribal customary adoption exists. So, you know, always be looking at that rather than a termination of parental rights. Any other questions about any of this?
Oh, there's one more question. At what point does the tribe review the home study and or let us know the RFA study is not acceptable?
Good question. So you walk into your permanency hearing, right? Your Welfare and Institutions Code 366.26 hearing. And there's a discussion between all parties about what the most appropriate permanent plan for this particular child is, right? So let's assume for the sake of this discussion that that is tribal customary adoption, and the state court judge orders tribal customary adoption to be the permanency option, and then that judge will continue the 2-6 hearing for up to 120 days, okay? During that 4-month period, the tribe is going to be developing that order and then looking at the home study, right? So if it's just a simple, review of RFA, that'll be pretty quick. If it is doing the full-blown home study, it's going to take a little bit longer. In either case, a tribe can approve it kind of as soon as it has reviewed the appropriate documentation. That said, my recommendation to my tribal clients was always that it made more sense to kind of hold off on formal approval until the tribal customary adoption order had been complete, that they go hand in hand, right? So kind of on the same date or around the same time, a tribe would, both review for approval the adoption order and the home study. It should happen within that 4-month window, though. There can be a continuance of up to 60 additional days. So that gives you an additional 2 months. That puts you at the 6-month mark, right? When TCA was first passed, we were seeing continuances that were well beyond 6 months because there were a ton of questions about, kind of how the transfer of jurisdiction worked, and who was going to do the home study, and all the confidentiality issues that go along with the home study, right? Like, I always visualize it as this kind of brick wall between, the child welfare side and the adoption side, right? Scott, can we go ahead and mute everybody, just because I think that some folks are having unintentional background conversations, not knowing that they're muted. So it is about, I got muted, but now I'm unmuted. Yay, thank you, Scott. But what I was saying is that we had real issues about the tribe getting access to the home study, right? So a tribe would designate the county to do the home study. The county would contract with a designated entity. The home study would be complete. And there would be a recommendation for approval by the licensed adoption agency, and then no one wanted to give it to the tribe, right? And the tribe had to approve it. So we've gotten beyond a lot of those. What I will say is that sort of beyond the 6-month mark, there should be a really good reason if additional continuances are needed, and that those just need to be on the record, because delaying permanency for any child is not in the best interest of that particular child. And once you have the orders in place, then that you have to run through the appeal timeframes, right? And so all of that sort of eats into an eventual permanency, like a real permanent situation for a child. So that's kind of a long-winded answer, but hopefully that's helpful. And, you know, RFA and tribal placements is not syncing very well in general. And again, I work for an organization called California Tribal Families Coalition. One of the bills that we have introduced this legislative session, AB either 685 or 686, those are both ours, but it seeks to really clarify how RFA interfaces with tribally approved homes, with tribally specified homes, and with tribal customary adoption. So, you know, again, really trying to find that sort of sweet spot where we can create some harmony between, you know, these laws that apply specifically to Indian children and California laws, so that it's just so much more seamless in actual application. But I am happy to share my personal information. And Scott, I don't know if I can send, if I send that to you, can you email that out? Is that a good way to do it?
Yes, I can do that.
Okay. So I will share with Scott my contact information. If you have any additional questions that come up about any of this, I talk about ICWA all day, every day. And I'm more than happy to talk with you. If your individual county, you know, finds a need to elaborate on any portion of this, or to actually do a much more in-depth in-person training, you know, we do a lot of those. Really also try to partner with local tribes in the development of those trainings. So do feel free to reach out with individual questions, or if you would like, you know, more comprehensive training. You know, you really got a lot kind of thrown at you pretty quickly. But I think that it's enough for you to identify all of those individual points within a case, you know, where you need to know how ICWA applies. And yes, the PowerPoint can be shared via email. There will be one other document that's also shared via email, and it is specific to tribal customary adoption. So you'll get an email with the PowerPoint from today, and then some information about tribal customary adoption, and then also my contact information. You're welcome. Thank you all for joining us. I'm going to go ahead and hang out here for another 5 minutes or so if anybody has any additional questions. But feel free to go and have lunch. Thank you so much for your time. And if you want to hang out here and engage in any further discussion, then thank you for doing that. Choice is yours. One additional question, is it typical or acceptable to change a child's name? That's something that if you're talking about a tribal customary adoption, which I assume you are, it's up to the tribe. Some tribes feel very, very strongly that you should not change a child's name. You know, other tribes in other situations, it has not been a problem at all. You know, that it's really specific to, you know, that particular case. You know, we have a tribe that we work with that, one, in typical situations, did not change the child's name and required the biological parents to be on the birth certificate. But because of the nature of the situation that led to the removal, the tribe found in that particular case that the biological parent's name should not be on the birth certificate, that the tribe still felt that you cannot terminate a parent's rights, that it's not in the best interest of Indian children to do so because of the rights that flow from that biological connection to an Indian parent in the tribe. But, you know, because of the facts of that particular case, the biological parent's name is not on the birth certificate, and the adoptive parents were given the right to change the child's name. So again, absolutely case by case, you would have to work very closely with the tribe. And that would be, yes, that would be actually in the tribal customary adoption order itself. And those tribal customary adoption orders, end up often being fairly comprehensive in nature and including things like ongoing contact with the child's tribe, right? So they might include something like, the child is required to attend, at least 2 of the following 5 tribal ceremonies each year. And it may also include something like the child or the adoptive parents must make the child available to spend at least 2 consecutive overnights with, the parental grandparents. We have worked with tribes to really hopefully, help them understand that, having very concrete visitation, something like, child has to be with grandparents from 10 to noon, every Saturday, doesn't work because this is not a visitation order within a juvenile dependency case, right? That it's an adoption order, and adoption orders by their very nature should be able to grow with a particular child, right? And while, that kind of specific visitation order may very well work for a 3-year-old who lives down the street from grandma, it's probably going to be much more difficult for a 13-year-old, right, who wants to play soccer every Saturday or, whatever that case may be. But also, it's in deference to the fact that it's an adoption, right? That you have parents that are coming in and adopting this child, and that there needs to be a real respect of the fact that they will be the child's parents, and that the intention of the tribal customary adoption is, one, to avoid that termination of parental rights that we've talked so much about, but also to ensure an ongoing connection between the child's tribe, and the child's extended family. But it is not intended to, kind of be this, this oversight of everything that an adoptive parent does. And, we see more tribal customary adoptions in cases involving non-Indian parents than anything else. And the way that these orders end up getting developed, more often than not, is that the tribal court, or if it's the tribal council within that particular tribe sitting as the child's court, then it would be that council, whoever it is that's hearing this particular case, right, would provide notice to parties, and there would be a discussion then before that particular group or individual, again, totally depends on the tribe and the structure of the tribe, about what those orders would look like. We always recommend that a draft of the tribal customary adoption order is sort of shared among, the adoptive parents, the parents, the biological parents, the minor's attorney, and then county council. Because ideally, in these cases, by the time you've gotten to this particular stage, there can be some resolution, right? And, often, Indian parents are still very upset because reunification services have been terminated. But where there can be a discussion of, yes, reunification services have been terminated, but termination of your parental rights will not be happening. And, it is possible that through the tribal customary adoption order, and likely at the discretion of the adoptive parents, that there can be some continued contact between the parent and the child, right? But kind of operating without that information, can still lead a parent to be really upset about the direction a case has gone. So it's just, it's important to kind of walk through what those options look like, but they're going to have to work with the tribe. And again, because you have, a new set of parents that are coming in through this process, those individuals need to be given a large amount of discretion. Like, I have not seen any tribal customary adoption orders that dictate that, biological parents, sort of shall have continued custody. That is at the discretion of the adoptive parents. Often it's reliant on claimed drug testing, sometimes just one, but You know, in other cases, we've seen as much as, you know, 6 months of consecutive clean drug tests and, you know, breathalyzer use, you know, just before, and that runs through the tribal social services department. So it's not a burden on adoptive parents. There's a lot of creative ways that these orders have been able to kind of minimize conflict for all parties, and recognition of the fact that it's always in the best interest of all children to be surrounded by a community of people that love them, right? And Scott has also asked me to let everyone know that the link to the recording of today's session will be available.
Then there was also one other question: are the TCA orders negotiable? Can you answer that or not?
I wouldn't say negotiable, although I guess you could look at it in that way. Instead, it's usually an opportunity to be heard by the forum developing the order. Although in some cases, you know, you may have a tribal attorney that's sort of sharing it out, in which case, you know, if there are particular issues within the tribal customary adoption order that a party is not comfortable with, and then sure, those should be brought up. You know, at the end, and the reason why I say not necessarily sort of negotiable, is they would be negotiable, I guess, to the extent that, you know, a state court judge, you know, ultimately will make a decision after hearing from all parties, right? So it's that same setup, but instead of a state court judge making that determination, that it would be the tribal court judge or the tribal council, which is the tribe's governing body, that would be making that determination based on input from relevant parties. Does that answer your question? Awesome. We are in the process of our first tribal customary adoption, so we have lots of questions. This was very helpful. I'm so glad, and you're very welcome. And I would be very happy to talk with you about any barriers that you run into with your very first tribal customary adoption. I actually got to work with an Alaskan village, the native village of Eklutna, on the second tribal customary adoption that was finalized in the state of California out of Shasta County. And the little girl is a friend of mine on Facebook, and she's doing spectacularly well. She is completely immersed within the native village of Eklutna and the native village of Knik, and she plays soccer and has a moose that she thinks is her best friend in the backyard. And her mom continues to reside in Shasta County, where she seems to be doing a bit better. And there's continued contact there and continued contact with her siblings here in California. And it has worked out really, really well. I look forward to hearing from you. I think webinars are so weird where I can't actually talk to you or see you. But you can hear me.
Power of technology.
Yes. I'm curious, Michelle, what county are you from? Awesome. Monterey, cool.
Oh yeah, so she was her and her group. Yeah, they were kind of the ones that got the whole ball rolling as far as this topic. So thank you.
Absolutely. You know, I also, when I was with California Indian Legal Services, I recorded a webinar on tribal customary adoption as a part of a CDSS grant that's posted on YouTube on the California Indian Legal Services channel. It may be helpful for you to take a look at that webinar as well. It's not, we did not in that webinar cover sort of the basics of ICWA. It is just specific to tribal customary adoption. And Scott, we may want to look at doing something like that here too. It's just doing, because that one at this point, I want to say is 4 years old, maybe 5 years old.
Okay. Yeah, because Monterey, they're typically they're not a part of our training jurisdiction. They're part of Bay Area Academy. But glad they were able to reach out. And, they would get in contact with Bay Area Academy as well.
Awesome. Such a beautiful place.
I agree.
Okay. Well, with that, I think we're going to go ahead and close. Scott will be, again, providing you with the link to the webinar that was recorded today, the information on tribal customary adoption, the PowerPoint that we walked through today, and of course, my contact information. And it would be lovely to hear from you. And just again, thank you all for participating and hope that you found this useful.
Wonderful. Thank you. Thank you, Delia.
Thanks, Scott.
Bye, everyone.
Bye.